Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
So on today's episode of the podcast, we're covering a very important criminal proceeding case, the Queen and Antic. And the short synopsis of Antic is, you'll know it if you take criminal procedure. It stands for what's commonly referred to as the ladder principle in what we call show cause or bail hearings. The funny thing about this area of criminal law, like criminal procedure, is there is so much like unique terminology that if you don't know what it means, it's like another language. Like law is a language, criminal procedure is a language within that language that you need to learn. So I'm still learning it because it's something that I'm going to be doing at my current articling position. So I'm still trying to wrap my head around it. And this was a great chance for me to revisit Antic and get back to like the starting point of show cause hearings or bail hearings.
Yeah, definitely. I also took it in criminal procedure, and I took it with Professor Rogan, who's like the bail expert, Jillian Rogan. She knows all the things about bail that have ever happened or ever will happen. She's brilliant. So this is actually, I'm not a criminal procedure person, but this is one of the things that I actually both know and enjoy learning about criminal procedure. And it's so funny you're talking about the language, because I find, because you and me have both worked on both sides of the criminal procedure situation, and it's funny how the language is different even on both sides. So something that, you know, we called one thing at the community legal clinic, it's like they call it different, something else on the other side. And I was just like, it's like a language and then a dialect, right? It's not even the same amongst the criminal bar because it changes if you're on defense or crown. It's crazy. It is its own kind of weird language that functions in this strange way.
Which almost begs the question, does it vary from region to region? Because like that almost terrifies me, because I'm sure every criminal bar has their own local lexicon, right?
Oh, yeah.
They just use terminology that, you know, may not exist in Windsor, that may not exist in Toronto, that may exist somewhere else. So that's a funny one to think about too.
Oh yeah, no, and I
like Antic. I like Antic as a starting point.
No, it's definitely good, and it codifies a principle. You know what I mean? Like it's codifying, or it's setting out the ladder principle that then gets codified into the code. I was going to say, as a slightly tangential aside, one of the things that's like the most terrifying to me as someone who's entering like kind of litigation is that all the courts in Ontario do things in different ways. Because you will know this, that the OCJ in Windsor calls things backwards, which I didn't know until I went somewhere else. And then I was like, oh, dear God, what is happening? I'm so confused. And it's definitely like a culture shock to realize that because, you know, this is something that doesn't necessarily come up in law school. You sort of learn it through practice. And it's just like, oh, every single court here has different practice directions and they're all going to do things slightly differently. And like that feeling of terror that I'm going to embarrass myself is never going to go away, is it? Like it's
I remember when I was in the Army, they have something called standards. Standards administers all the tests to ensure that everyone achieves the same standard, right? The most horrifying moment of like my like teaching career when I was in the Army was a standards officer came up to me and he said, "Standards aren't standard." And I was like,
no, please stop. That's giving me hives. I hate that. Please stop.
Yeah. And the same applies here, right? Like the standard procedure in Windsor is not the standard procedure in Chatham or London or downtown Toronto.
It's terrifying, but it does also speak to like, and I mean, I might sound like some sort of like out of touch hippie praise-loving millennial, but like civility is definitely so important and so appreciated. I can't think of anything worse than like when you're in an unfamiliar courthouse and no one's helping you. It's just the most terror-striking feeling. Whereas, you know, when counsel are just general kindness to each other, and, you know, even if you're on opposite sides of something, just being generally kind and civil in how you're dealing with people is so appreciated. It goes so far. It's, you know, I can still remember people who were kind to me when I was like lost in a building trying to find the right courtroom, right? You never forget that stuff.
And it doesn't hurt just to, you know, if you can see that somebody's not doing something right, it doesn't hurt to be like, oh, like this is how it's done here.
Yeah, no, exactly. Because
it goes a mile.
Oh, yeah, definitely. Well, we got a little off topic with that one, Zach, but
well, it's a podcast. Isn't that what podcasts are for?
It's true. We're not quite Joe Rogan yet, but we're getting there.
Yeah, slowly. We're not quite at the 4-hour length, fortunately. But anyways, guys, the ladder principle, you'll learn about it. Basically, there are 3 steps: primary, secondary, and tertiary. The case gets into it. I won't waste a bunch of time here explaining it because you'll learn it in criminal procedure if you're a student, and if you're a practitioner, you have, I'm sure, ample opportunity to review it like myself. So anyways, guys, thanks for listening, and I hope you enjoy The Queen and Antic. The Queen and Antic. On appeal from the Ontario Superior Court of Justice, 2015, ONSC 6593, declaring that Section 515 Sub 2 Sub E of the Criminal Code unconstitutional and granting the accused judicial interim release, appeal allowed. The judgment of the unanimous court was provided by Justice Wagner. 1. Overview. The right not to be denied reasonable bail without just cause is an essential element of an enlightened criminal justice system. It entrenches the effect of the presumption of innocence at the pre-trial stage of the criminal trial process and safeguards the liberty of accused persons. This case required the court to clarify the important aspects of the law of bail, specifically when a judge or justice of the peace can impose a cash deposit on an accused as a condition of release. At issue are the interpretation and constitutionality of Sections 515 Sub 2 Sub E of the Criminal Code, which authorizes one form of a pretrial release. Section 515 Sub 2 Sub E permits a judge or justice to require both a cash deposit and a surety supervision as conditions of release if an accused ordinarily resides out of the province or is more than 200 kilometers away from the place in which he or she is in custody. But this form of combined quote, cash plus surety, end quote, release is not available to accused persons who do not meet these geographic criteria. The judge who heard the bail review application in this case, quote, the bail review judge, held that Section 515 Sub 2 Sub E violates the right not to be denied reasonable bail without just cause under Section 11E of the Canadian Charter of Rights and Freedoms because it had the effect of denying bail to the respondent, Kevin Antic. The bail review judge erred in the coming to this conclusion. Section 515 Sub 2 Sub E did not have the effect of denying Mr. Antic bail. It was the bail review judge's misapplication of the bail provisions that did so. The quote, ladder principle, end quote, which is codified in Section 515 Sub 3 of the Code, requires a judge or justice to impose the least onerous form of release on an accused unless the Crown shows why that should not be the case. The bail review judge failed to adhere to this central principle. He erred by requiring a cash deposit with a surety, one of the most onerous forms of release, even though Mr. Antic had offered a surety with a monetary pledge, known in the Code as a recognizance. A cash deposit and a monetary pledge both give an accused the same financial incentive to abide by his or her release order. Neither is more coercive than the other, but requiring cash can be unfair as it makes an accused person's release contingent on his or her access to funds. Thus, cash bail is merely a limited alternative to a pledge that should not be imposed where accused persons or their sureties have reasonable recoverable assets to pledge. I would allow the appeal. Mr. Antic has offered to provide sureties with a monetary pledge. He could have been released without a cash deposit. Therefore, there is no need to address the question whether Section 515 Sub 2 Sub E violates Section 11E of the Charter. Yet the concerns raised in this case extend beyond the provision at issue. The bail review judge's reasons appear to be illustrative of how the bail provisions are being applied inconsistently across the country. While the bail hearing is admittedly an expedited procedure, the bail provisions are federal law and must be applied consistently in all provinces and territories. This case affords an opportunity to determine the proper approach to applying those provisions, one that is consistent with the right not to be denied reasonable bail without just cause under Section 11E and with the presumption of innocence. 2. Relevant provisions. Section 11E of the Charter reads as follows. 11. Any person charged with an offense has the right, sub E, not to be denied reasonable bail without just cause. And the relevant portions of section 515 of the Code read as follows. 515 sub 1. Subject to this section, where an accused who is charged with an offense other than an offense listed in section 469 is taken before a justice, the justice shall, unless a plea of guilty by the accused is accepted, order, in respect of that offense, that the accused be released on his giving an undertaking without conditions, unless the prosecutor, having been given a reasonable opportunity to do so, shows cause, in respect of that offense, why the detention of the accused in custody is justified, or why an order under any other provision of this section should be made, and where the justice makes an order under any other provision of this section, the order shall refer only to the particular offense for which the accused was taken before the justice. Sub 2. Where the justice does not make an order under subsection 1, he shall, unless the prosecutor shows cause why the detention of the accused is justified, order that the accused be released, A, on his giving an undertaking with such conditions as the justice directs, B, on his entering into a recognizance before the justice, without sureties, in such amount and with such conditions, if any, as the justice directs, but without deposit of money or other valuable security. C, on his entering into a recognizance before the justice with sureties in such amount and with such conditions, if any, as the justice directs, but without deposit of money or other valuable security. D, with the consent of the prosecutor, on his entering into a recognizance before the justice without sureties, in such amount and with such conditions, if any, as the justice directs, and on his depositing with the justice such sum of money or other valuable security as the justice directs, or E, if the accused is not ordinarily resident in the province in which the accused is in custody, or does not ordinarily reside within 200 kilometers of the place in which he is in custody, on his entering into a recognizance before the justice with or without sureties in such amount and with such conditions, if any, as the justice directs, and on his depositing with the justice such sum of money or other valuable security as the justice directs. Sub 3. The justice shall not make an order under any paragraph of 2 sub B to E unless the prosecution shows cause why an order under the immediately preceding paragraph should not be made. Sub 4. The justice may direct as conditions under subsection 2 that the accused shall do any one or more of the following things as specified in the order. A. Report at times to be stated in the order to a peace officer or other person designated in the order. B. Remain within a territorial jurisdiction specified in the order. C. Notify the peace officer or other person designated under paragraph A of any change in his address or his employment or occupation. D. Abstain from communicating directly or indirectly with any victim, witness, or other person identified in the order, or refrain from going to any place specified in the order, except in accordance with the conditions specified in the order that the justice considers necessary. E. Where the accused is the holder of a passport, deposit his passport as specified in the order. E.1. Comply with any other conditions specified in the order that the justice considers necessary to ensure the safety and security of any victims or witnesses to the offense, and F. Comply with such other reasonable conditions specified in the order as the justice considers desirable. 3. Background and judicial history. Mr. Antic was arrested in Windsor, Ontario, and charged with several drug and firearms offenses. He is an Ontario resident, but he spends much of his time in the state of Michigan and has no assets in Canada. Mr. Antic's initial bail hearing occurred after he was arrested. A. Ontario Court of Justice, Justice of the Peace Renault, number C57727, June 30th, 2015. At the bail hearing, the Justice of the Peace denied Mr. Antic's release. Because Mr. Antic was charged with drug trafficking, the presumption in favor of pretrial release did not apply, and he bore the burden of justifying his release. Criminal Code, Section 515, sub 6. The justice concluded that having Mr. Antic's girlfriend supervise him as a surety would address any safety concerns. However, because Mr. Antic had no significant ties to the local community, the justice found that his release plan did not adequately address the substantial flight risk that he posed. Ontario Superior Court of Justice, Justice Moreau, July 17, 2015. Mr. Antic sought a review of the detention order under Section 520 of the Code. He offered a pledge or a deposit of money as well as 2 additional sureties, his father and his grandmother, to satisfy the flight risk concerns. The bail review judge rejected the new release plan and declined to vacate the detention order. He insisted on a cash deposit because he was worried that Mr. Antic could abscond if what was at stake was, quote, a mere pledge, end quote, of $10,000 from his grandmother. The bail review judge speculated that Mr. Antic would assume that if he breached his bail conditions, the government would not seize his elderly grandmother's house. The bail review judge did not consider Mr. Antic's girlfriend as a potential surety, even though she was available at the time. The bail review judge wrote that he would have released Mr. Antic if he could have imposed both a surety and cash deposit as release conditions in order to satisfy the flight risk and safety concerns. However, Section 515 sub 2 sub e of the Code permits a cash plus surety release only if the accused is from out of the province or does not ordinarily reside within 200 kilometers of the place in which he or she is in custody. As an Ontario resident living within 200 kilometers of the place in which he was detained, Mr. Antic did not qualify for this. Ontario Superior Court of Justice, Justice Moreau, August 28, 2015. In his second bail review application, Mr. Antic argued that the following new facts justified his release. 1. He had pleaded guilty to the drug trafficking charges and had been sentenced to a short term in jail, which he had already served in pretrial custody. 2. The handgun found under his bed had been misclassified as a .40 caliber weapon. And 3. His co-accused had been released on bail. And 4. There was a potential for delay in obtaining a date for preliminary inquiry on the remaining charges he faced. The bail review judge disagreed. He was still concerned that Mr. Antic would abscond regardless of the changed circumstances. Ontario Superior Court of Justice, Justice Monroe, 2015, ONSC 6593, October 23, 2015. Mr. Antic sought a third bail review, this time challenging the constitutionality of Section 515 sub 2 sub e. The bail review judge found that Section 515 sub 2 sub e violates the right not to be denied reasonable bail without just cause under Section 11e of the Charter. He held that the only viable condition of release for Mr. Antic would be a large cash deposit and surety supervision. However, the geographical limitation in Section 515 sub 2 sub e prevented him from granting bail on these terms. The bail review judge thus concluded that the geographical restriction unconstitutionally denied Mr. Antic bail. He severed and struck down the geographical limitation in Section 515 sub 2 sub e. He then ordered Mr. Antic's release with a surety and a cash deposit of $100,000. This court granted the Crown leave to appeal the bail review judge's decision, as the Crown had no right to appeal a bail review decision made under Section 520 to the Provincial Court of Appeal. See the Queen and Smith at paragraph 25 and the Supreme Court Act at Section 40 sub 1. After over a year in pretrial custody, Mr. Antic raised sufficient funds to post a $100,000 cash deposit and was released on July 15, 2016. 4. Issue. Does Section 515 sub 2 sub e of the Criminal Code infringe on the right not to be denied reasonable bail without just cause under Section 11e of the Charter? Part 4. Analysis. A. Concept and history of bail. When someone is charged with a crime, the Code and the Charter typically require that the accused be released from detention before trial on what is known as, quote, bail, end quote. Although release is the default position in most cases, a judge or justice also has the authority to deny the release of an accused or to impose conditions on the accused when he or she is released, provided that the Crown justifies the detention or the conditions. The Code primarily utilizes the expression, quote, judicial interim release, end quote, to refer to, quote, bail, end quote. And these reasons, I will use the terms bail and pretrial release interchangeably in referring to this concept. The concept of bail traces back to English antiquity. Early codifications of the law of bail included the Statutes of Westminster I in 1257, which structured the terms under which judges could grant bail, the Bill of Rights of England in 1688, which prohibited excessive bail conditions. By the 1800s, the sole purpose of the law of bail in England was to ensure that accused persons who were released on bail would attend their trials. See G.T. Trotter, The Law of Bail in Canada. Bail has deep historical roots in Canada as well. Canadian law reflected the English law of bail until Parliament enacted legislation in 1869 that made bail discretionary for all offences. See an act respecting the duties of justices of the peace out of sessions in relation to persons charged with indictable offences, as well as the Queen and Hall, the Queen and St. Cloud. In Dissenting Reasons in Hall, Justice Iacobucci explained that older versions of the code had provided justices, judges, and magistrates with no real guidance on bail. Before 1972, the law of bail was a highly discretionary matter. It was presumed that an accused person would be detained prior to trial unless he or she applied for bail under Section 463 Sub 1 of the Criminal Code. And Section 463 Sub 3 gave virtually no guidance to the bail judge charged with determining whether to detain an accused committed for trial. The provisions of the pre-1972 Code also gave no guidance on the imposition of release conditions. There were three forms of release: A. Release with sufficient sureties upon entering into a recognizance; B. Release upon making a cash deposit; and C. Release upon entering into a recognizance without a deposit. These forms of release were not ranked in any way, which meant that a justice, a judge, or a magistrate could impose any of them in any given case. Pioneering work by Professor Martin L. Friedland and by the Canadian Committee on Corrections sparked a significant reform of the bail system. Professor Friedland's study, Detention Before Trial, specifically examined the practice of bail courts in Toronto. The Canadian Committee on Corrections, established in 1965 by Order in Council, examined more broadly the Canadian criminal process and correctional system, including the law of bail. It delivered its recommendations in a report that is now known as the Ouimet Report, after the committee's chairman, Justice Roger Ouimet of the Quebec Superior Court. Both Professor Friedland and the authors of the Ouimet Report recognized that the bail system's over-reliance on cash bail limited the possibility of release for many accused persons. Professor Friedland observed that there was an, quote, undue preoccupation with bail's monetary aspects, end quote. Generally, magistrates required accused persons to deposit cash before they would release them. This led to an unconscionable result, quote, the ability of the accused to marshal funds or property in advance, end quote, determined whether he or she would be released. Professor Friedland also mentioned some of the practical challenges involved setting the quantum of a cash deposit, as well as the unfairness it produced. A system which requires security in advance often produces an insoluble dilemma. In most cases, it is impossible to pick a figure which is high enough to ensure the accused appearance in court and yet low enough for him to raise. The two seldom, if ever, overlap. The 1972 Bail Reform Act was an attempt to address these concerns by placing strict limits on cash bail. Then Justice Minister John Turner, speaking in the House of Commons, recognized that requiring a cash in advance to secure pretrial release could operate, quote, harshly against poor people, end quote. He stated that, quote, cash bail in this bill is only a last resort, end quote, and that the bill was intended to limit cash bail to circumstances in which, quote, the alleged offender was not ordinarily resident in the community where he was in custody, end quote. The Bail Reform Act also codified what is now known as the, quote, ladder principle, end quote. This act set out possible forms of release which were ordered from the least to the most onerous. The ladder principle generally requires that a justice not order a more onerous form of release unless the Crown shows why a less onerous form is inappropriate. In other words, the ladder principle means, quote, the release is favored at the earliest reasonable opportunity and on the least onerous grounds, end quote. See the Queen and Anusis. The latter principle and the authorized forms of release remain a central part of the Canadian law of bail and are now enumerated in Section 515 sub 1 to sub 3 of the Code. In the Code, the possibility of requiring a cash deposit is limited to the two most onerous forms of release. See Section 515 sub 2, sub D to E. In 1982, the enactment of the Charter transformed the statutory right to bail into a constitutional right. See the Queen and Pearson. I will now examine the Charter right not to be denied reasonable bail without just cause more closely. B. Interpretation of Section 11E of the Charter. Section E of the Charter states, quote, "Any person charged with an offence has the right not to be detained reasonable bail without just cause," end quote. This right creates, quote, "a basic entitlement to be granted reasonable bail unless there is just cause to do otherwise," end quote. Pearson at page 691. Before proceeding, I must mention that the expression, quote, "just cause," end quote, is used in two senses in the bail context. First, as used in the Section 11E of the Charter, quote, "just cause," end quote, relates to the circumstances in which denying bail is constitutional. An accused has a constitutional entitlement to be granted bail unless there is, quote, "just cause," end quote, to deny it. Second, the expression, quote, "just cause," end quote, is also commonly used to describe the statutory grounds that justify the pre-trial detention of an accused. These grounds, which are enumerated in Section 515.10 of the Code, are flight risk, public safety, and public confidence in the administration of justice. In most cases, it is presumed that the accused should be released, and he or she will not be detained unless the Crown can show on the basis of these statutory criteria that detention is warranted. In these reasons, I will use the expression, quote, "just cause," end quote, only in the constitutional sense. To avoid confusion, I will refer to the grounds under the Code as the, quote, "statutory criteria for detention," end quote. This court first interpreted the Charter right to bail in Pearson and the Queen and Morales. In Pearson, Chief Justice Lammer observed that the word bail in the Charter must be interpreted broadly and include, quote, "all forms of what is formally known under the Criminal Code as judicial interim release," end quote. He noted that the right under Section 11E has two aspects. One, the right not to be detained without, quote, "just cause," end quote, and two, the right to, quote, "reasonable bail," end quote. In Pearson and Morales, the court considered the meaning of the first aspect of this right, that is, the right not to be denied bail without, quote, "just cause," end quote. This aspect, quote, "imposes constitutional standards on the grounds under which bail is granted or denied," end quote. The reasonable bail aspect, on the other hand, concerns the terms and conditions of release. I will briefly summarize Chief Justice Lammer's discussion on this two-part right, after which I will consider the provision at issue in the case at bar. 1. Right not to be denied bail without, quote, "just cause," end quote. A statutory provision that allows for the pretrial detention of an accused triggers the protection of Section 11E. For example, the court held in Pearson that Section 515.6d of the Code constitutes a denial of bail under Section 11E because it puts the onus on an accused to justify pretrial release if he or she is charged with certain offenses. Since this reverse onus amounts to a presumption in favor of detention, quote, "there is a departure from the basic entitlement to bail that is sufficient to conclude that there is a denial of bail for the purpose of Section 11E. A provision may not deny bail without, quote, "just cause," end quote. The right not to be denied bail without just cause imposes a constitutional standard that must be met for the denial of bail to be valid. Chief Justice Lammer held that there is just cause to deny bail only if the denial, 1, occurs in a narrow set of circumstances, and 2, the denial of bail is, quote, "necessary to promote the proper functioning of the bail system and is not undertaken for any purpose extraneous to the bail system." 2. Right to reasonable bail. In contrast to the first aspect of Section 11E, the right to reasonable bail relates to the terms of bail, including the, quote, "quantum of any monetary component and other restrictions," end quote, that are imposed on the accused for the release period. The right not to be denied reasonable bail without just cause protects the accused person from conditions and forms of release that are unreasonable. The French version of Section 11E bears this out. A person charged with an offense has the right to release assorti d'un cautionnement raisonnable. It must be borne in mind that Section 515 sub 2 of the Code establishes the only legal forms of pretrial release, such as a surety release or release with a recognizance. But it is the justice or judge who ultimately decides which form of release to order in a given case, and he or she also has discretion under Section 515 sub 4 of the Code to impose terms that are specific to the circumstances of the accused. Both a legislated form of release and the specific terms of release ordered by a justice or a judge can be unreasonable and, as a result, unconstitutional. C. Provision at issue, Section 515 sub 2 sub e. On the basis of these constitutional principles, I will begin by discussing the proper interpretation of the challenge provision, Section 515 sub 2 sub e of the Code, and the scheme governing the forms of release. I will then explain why I do not need to address Section 11e of the Charter. 1. Proper interpretation of Section 515 sub 2 sub e and the scheme governing the forms of release. To interpret Section 515 sub 2 sub e, it is first necessary to understand the latter principle. As I explained above, the latter principle requires that the form of release imposed on an accused be no more onerous than necessary. This principle is set out in Section 515 sub 1 to sub 3 of the Code. Although these provisions are more strictly applicable in a contested bail hearing, they also provide the legal backdrop that should guide plans of release to which the parties consent. Section 515 sub 1 requires that, where an accused is charged with an offense other than the ones listed in 469 of the Code, quote, the accused be released on his giving an undertaking without conditions, end quote. However, Section 515 sub 1 affords the prosecutor an opportunity to show why the accused should either be detained or be released under more onerous forms of release. The Code also requires that accused persons charged with any of the offense listed in Section 515 sub 6 be detained unless they justify their release. Aside from the release of an accused person under Section 515 sub 1 on his or her giving an undertaking without conditions, Section 515 sub 2 sets out other permissible forms of pretrial release. Where the justice does not make an order under subsection sub 1, he shall, unless the prosecutor shows cause why the detention of the accused is justified, order that the accused be released, on his giving an undertaking with such conditions as the justice directs, on his entering into a recognizance before the justice without sureties in such amount and with such conditions, if any, as the justice directs but without deposit of money or other valuable security, on his entering into a recognizance before the justice with sureties in such amount and with such conditions, if any, as the justice directs but without deposit of money or other valuable security, with the consent of the prosecutor on his entering into a recognizance before the justice without sureties in such an amount and with such conditions, if any, as the justice directs, and on his depositing with the justice such sum of money or other valuable security as the justice directs, or, if the accused is not ordinarily resident in the province in which the accused is in custody or does not ordinarily reside within 200 kilometers of the place in which he is in custody, on his entering into a recognizance before the justice, with or without sureties in such amount and with such conditions, if any, as the justice directs, and on his depositing with the justice such sum of money or other valuable security as the justice directs. Each provision, moving from Section 515 sub 2 sub a to Section 515 sub 2 sub e, involves more burdensome conditions of release for the accused than the one before it. These forms of release, coupled with specific release terms a justice or judge may impose under Section 515 sub 4, have significant potential to impede on an accused person's liberty. The latter principle is codified in Section 515 sub 3, which prohibits a justice or a judge from imposing a more onerous form of release unless the Crown shows why a less onerous form is inappropriate. Quote, the justice shall not make any order under paragraph 2b to E unless the prosecutor shows cause why an order under the immediately preceding paragraph should not be made, end quote. Parliament included cash in the most onerous, quote, rung, end quote, of the latter for added flexibility, not because cash is more effective in other release conditions in ensuring compliance with the bail terms. A recognizance creates the same financial incentive for the accused to comply with the terms of release as does a cash deposit. One does not mitigate the flight or safety risk posed by an accused person more effectively than the other. The central purpose of the Bail Reform Act was to avoid the harsh effects on accused persons of requiring cash deposits where other avenues of release are available. As the authors of the Ouimet report recognized, cash bail provides added flexibility by offering an alternative form of release where a meaningful recognizance cannot be given and a surety cannot be obtained. Therefore, where a monetary condition of release is necessary and a satisfactory personal recognizance or recognizance with sureties can be obtained, a justice or a judge cannot impose cash bail. A pledge and a deposit perform the same function. The accused or the surety may lose his or her money if the accused person breaches the terms of bail. Release with a pledge of money thus has the same coercive power as release with a cash deposit. 2. Proper application of Section 515 sub 2 sub e in the scheme governing the forms of release. With these interpretive principles in mind, I will now turn to the bail review decision at issue in this appeal. Mr. Antic's show cause hearing and bail reviews were contested. Mr. Antic bore the onus of establishing why the detention order should be vacated. However, once Mr. Antic had satisfied the bail review judge that new circumstances justified his vacating the order, the latter principle ought to have guided the judge in fashioning a release order. Although Mr. Antic had been charged with drug trafficking, which had reversed the onus at the initial bail hearing, he had pleaded guilty to these charges by the time of his second bail review hearing. He was therefore not in a reverse onus position at that time. No party disputes that Mr. Antic posed a flight risk and a safety risk, but the bail review judge committed two errors in fashioning Mr. Antic's release order. First, the bail review judge failed to apply the latter principle properly. Although he purported to apply it, he erred by insisting on cash despite the existence of other forms of release. The bail review judge was fixated on a cash deposit because he believed the erroneous assumption that cash is more coercive than a pledge. But, as I explained above, a recognizance is functionally equivalent to cash bail and has the same coercive effect. The bail review judge should not have insisted on a cash deposit where the accused could have entered into a recognizance with a surety, the effect of which is that the surety joins in acknowledging the debt to the Crown. The bail review judge's second error may have in fact influenced the first. He expressed concern that, quote, the pull of bail, end quote, would not be strong enough without a cash deposit. Because the proposed surety was an elderly woman, the bail review judge was concerned that Mr. Antic might believe that a forfeiture proceeding would not be taken against her if he breached his bail terms. The bail review judge erred in making his decision on the basis of such conjecture. A justice or a judge cannot impose a more onerous form of release solely because he or she speculates that the accused will not believe in the enforceability of a surety or a pledge. The bail system is based on the premise to attend court made by accused persons on their belief in the consequences that will follow if such promises are broken. As Justice of Appeal Rosenberg rightly observed, quote, if accused came to believe that they could fail to attend court without their surety suffering any penalty, the surety system would be ineffective, end quote. Parliament expressly authorized the possibility of an accused being released on entering into a recognizance with sureties in the place of cash bail. Justices and judges should not undermine the bail scheme by speculating, contrary to any evidence and to Parliament's intent, that requiring cash will be more effective. Additionally, it now appears obvious that the quantum of the cash deposit set by the bail review judge was beyond the readily available means of the accused and his sureties. Courts have long held that it isn't permissible to, quote, fix the amount of a surety or cash deposit so high as to effectively constitute a detention order, end quote, which means that the amount should not be beyond the readily available means of the accused and his or her sureties. As a result, a justice or judge setting bail under a positive obligation, quote, to make inquiries into the ability of the accused to pay, end quote, see the Queen and Brost. At the same time, the amount must be no higher than necessary to satisfy the concern that would otherwise warrant detention. Even though Mr. Antic testified that he had no assets in Canada and the proposed sureties testified that they did not have ready access to large sums of cash, the bail review judge set his cash bail at $100,000. Unsurprisingly, it took Mr. Antic many months in custody to raise the money needed to satisfy this release condition. Not only was the bail review judge's reliance on cash bail unreasonable in that he did not correctly apply the latter principle, but the quantum he chose also became Mr. Antic's, quote, de facto prison, end quote, which is a sign that the amount may have been set too high. Parliament limited cash bail for good reason. All the parties and interveners recognize that cash bail can operate unfairly. This is consistent with the findings of Professor Friedland's study and that of the Wiemet report. To interpret Section 515 sub 2 sub e and the scheme governing the forms of release in a way that readily allows for increased resort to cash bail would be contrary to the intent of the Bail Reform Act and inconsistent with the right not to be denied reasonable bail without just cause enshrined in the Charter. As this case illustrates, requiring cash as a condition of release has the potential to result in increased incarceration of accused persons. Cash bail does not give impecunious persons greater access to bail. Rather, requiring a cash deposit will often prevent an accused person from being released, as it did for many months in Mr. Antic's case. Professor Friedland observed this in his study that a majority of accused persons who were required to deposit security as a condition of release were unable to raise the necessary funds. An accused person's release should not be contingent on his or her ability to, quote, to marshal funds or property in advance, end quote. Had the bail review judge applied the bail provisions properly, Mr. Antic could have been granted reasonable bail. Mr. Antic had suitable sureties and his sureties had available assets, but the judge's insistence on cash bail led him to err. The bail review judge's decisions should be reversed. 3. Does Section 515 sub 2 sub e violate the Charter? In this case, given that Section 515 sub 2 sub e did not have the effect of denying Mr. Antic bail, I cannot conclude that it denies him bail without, quote, just cause, end quote. Thus, the first aspect of the Section 11e right not to be denied reasonable bail without just cause is not triggered. If Section 515 sub 2 sub e had imposed a geographical limit on a form of release that performs a function different than that of money, such as a surety, it may indeed have denied an accused bail without just cause. But that is not what is at issue in this case. As I explained above, release with a pledge is functionally the same as release with a cash deposit. The fact that a cash bail would not be an option in Mr. Antic's case did not have the effect of denying him bail. Because the Crown had justified a monetary condition of release, Mr. Antic or his sureties should have been allowed to pledge money rather than being required to deposit money with the court. Furthermore, I do not need to address the second aspect of the Section 11e right. Properly interpreted, Section 515 sub 2 sub e does not apply to Mr. Antic and cannot therefore authorize an unreasonable form of release in his case. It is unnecessary to further elaborate on the meaning of reasonable bail. D. Proper approach to bail moving forward. Settling the proper interpretation of Section 515 sub 2 sub e and the scheme governing the forms of release does not resolve one concern that underlies this case. The bail review judge's errors appear to be symptomatic of a widespread inconsistency in the law of bail. One commenter, Kent Roach, observes an element of incongruity in the bail system, quote, although the Charter speaks directly to bail, the bottom line so far has been that remand populations and denial of bail have increased dramatically in the Charter era, end quote. Despite the fact that the code applies uniformly across the country, some have suggested that courts are applying the pretrial forms of release differently in different provinces and territories. For instance, Justice of Appeal Rosenberg, writing for a unanimous 5-judge panel of the Court of Appeal for Ontario, recognized that, quote, there may be now an over-reliance on sureties, end quote, in that province. Surety release also may be relied heavily on in the Yukon. In Alberta, some judges and justices are improperly imposing cash bail without seeking the consent of the Crown, even though doing so is prohibited by the Code. These examples suggest a divergence in the law of bail across this country. It is time to ensure that the bail provisions are applied consistently and fairly. The stakes are too high for anything less. Pretrial custody, quote, affects the mental, social, and physical life of the accused and his family, end quote, and may have a, quote, substantial impact on the result of the trial itself, end quote. An accused is presumed innocent and must not find it necessary to plead guilty solely to secure his or her release, nor must an accused needlessly suffer on being released. Courts must respect the presumption of innocence, quote, a hallowed principle lying at the very heart of criminal law that confirms our faith in humankind, end quote. Therefore, the following principles and guidelines should be adhered when applying the bail provisions in a contested hearing. A. Accused persons are constitutionally presumed innocent, and the corollary to the presumption of innocence is the constitutional right to bail. B. Section 11E guarantees both the right not to be denied bail without just cause and the right to bail on reasonable terms. C. Save for exceptions, an unconditional release on an undertaking is the default position when granting release. Section 515 sub 1. D. The latter principle articulates the manner in which alternative forms of release are to be imposed. According to it, quote, release is favored at the earliest reasonable opportunity and, having regard to the statutory criteria for detention, on the least onerous grounds, end quote. See anusis at paragraph 23. This principle must be adhered to strictly. E. If the Crown proposes an alternative form of release, it must show why this form is necessary. The more restrictive the form of release, the greater the burden on the accused. Thus, a justice of the peace or a judge cannot impose a more restrictive form of release unless the Crown has shown it to be necessary, having regard to the statutory criteria for detention. F. Each rung of the ladder must be considered individually, and it must be rejected before moving to a more restrictive form of release. Where the parties disagree on the form of release, it is an error of law for a justice or a judge to order a more restrictive form of release without justifying the decision to reject the less onerous forms. G. A recognizance with sureties is one of the most onerous forms of release. A surety should not be imposed unless all the onerous forms of release have been considered and rejected as inappropriate. H. It is not necessary to impose cash bail on accused persons if they or their sureties have reasonable recoverable assets and are able to pledge those assets to the satisfaction of the court to justify their release. A recognizance is functionally equivalent to cash bail and has the same coercive effect. Thus, under Section 515 sub 2 sub D or Section 515 sub 2 sub E, cash bail should be relied only on exceptional circumstances in which release on a recognizance with sureties is unavailable. I. When such exceptional circumstances exist and cash bail is ordered, the amount must not be set so high that it effectively amounts to a detention order, which means that the amount should not be beyond the readily available means of the accused and his or her sureties. As a corollary to this, the justice or judge is under a positive obligation when setting the amount to inquire into the ability of the accused to pay. The amount of cash bail must be no higher than necessary to satisfy the concern that would otherwise warrant detention and proportionate to the means of the accused in the circumstances of the case. J. The terms of release imposed under Section 515 sub 4 may, quote, only be imposed to the extent that they are necessary, end quote, to address concerns related to the statutory criteria for detention and to ensure that the accused can be released. They must not be imposed to change an accused person's behavior or to punish an accused person. K. Where a bail review is applied for, the court must follow the bail review process set out in St. Cloud. Of course, it often happens that the Crown and the accused negotiate a plan of release and present it on consent. Consent release is an efficient method of achieving the release of an accused, and the principles and guidelines outlined above do not apply strictly to consent release plans. Although a justice or a judge should not routinely second-guess joint proposals by counsel, he or she does not have the discretion to reject one. Although a justice or a judge should not routinely second-guess joint proposals by counsel, he or she does have the discretion to reject one. Joint proposals must be premised on the statutory criteria for detention and the legal framework for release. E. Remedy. Given the bail review judge's errors, I must reverse his declaration of unconstitutionality. Because Mr. Antic is ordinarily resident in the province of Ontario, his release order is no longer legal. Cash plus surety release is not available to local accused persons under Section 515 sub 2 sub E. This leaves Mr. Antic without a release order. At the hearing, the Crown consented to Mr. Antic's release with only a cash deposit under Section 515 sub 2 sub D, which means that the money he deposited would remain with the court. This would relieve Mr. Antic's surety of her duties. Given the Crown's consent, I would order that Mr. Antic's release order be replaced with one for his release under Section 515 sub 2 sub D. As I explained above, cash bail is generally inappropriate in a case such as this in which the accused has a surety and his surety has assets to pledge. But Mr. Antic is out on bail and does not need to be re-incarcerated. Since he has already posted the cash deposit, the simplest way to keep Mr. Antic out of custody is to convert his form of release to cash-only bail. Although the quantum of bail may also be excessive, it would be inappropriate for this court to vary the amount without the benefit of evidence from Mr. Antic and the Crown. The release order should retain the other conditions imposed by the bail review judge. Mr. Antic and the Crown retain the right to seek a variation of the release order. F. Disposition. I would allow the appeal, reverse the declaration of unconstitutionality, and replace the cash plus surety release order by the bail review judge with a cash-only release on the same terms as those he imposed. Appeal allowed.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.